morning. My name is Richard Wexler, and this is Caring in America, the podcast for caregivers and care recipients. So, longtime listeners know my story. About 20 years ago, minding my own business in the software industry, married later, two small kids. Summer of '05, the phone starts ringing. Turns out all four parents that we thought were doing very well were very ill. So we started that care journey that lasted for 14 years until the final parent passed at 96 in 2019. Started this podcast 2 years ago, and then in January launched A Plan to Age, our national foundation, which I'm running as the CEO. So we have a special guest this morning, Aaron Miller. I'm about to introduce him via his bio. Aaron is an award-winning elder law and estate planning attorney dedicated to helping families with long-term care. After starting his career in corporate litigation, he shifted his focus to avoid the high costs of long-term care that was inspired by his grandparents' struggles. Miller Law Office has been named the best law firm in Plano, Texas for 3 consecutive years, known for building strong relationships and providing services like Medicaid planning and family harmony protection. Are you there, Aaron?
I am. Hello. Thank you for having me today.
You're very welcome. So I assume you're sitting in Plano. Is that correct this morning?
I am at beautiful Plano, Texas today. Yep.
Very, very good. Well, what I'd like to do is kind of walk through some questions. Some of them may be somewhat basic, but really trying to help our audience get a better understanding of elder law, get a better understanding of the estate plan, the documents that go into it, all of that. So I'm going to start at the very top. What in the world is elder law?
Yeah, that's a great question, Richard. I always say that estate planning is what happens if you get sick and die. Elder law is more of what happens if you get sick and don't die. Who's going to be making your legal decisions? Who's going to be making your medical decisions? How are you going to pay for care, and where are you going to get care? So that's the kind of things that we talk about with elder law. More specifically, what I do is if we have a loved one who's in a nursing home, we help figure out how to get qualified for the available government benefits.
Interesting. So how long have you been practicing now, both elder law and estate planning?
So I got my license in 2002. I originally was a litigation attorney, and I switched over in 2009. So since 2009, I've been focusing exclusively on estate planning, elder law, and I've been doing estate administration as well.
Interesting. So from an elder law perspective, who normally is reaching out to you? Is this the older loved one themselves? Are these the adult children? Who's making initial contact with you?
It depends. A lot of times it's maybe the spouse of the person who's sick that needs the care. But just as often is the kids. And what I found, it's more often than not, it's usually the oldest daughter, or if there are no daughters, it's often the oldest daughter-in-law that seems to be the one that is providing the care and very, very interested in what's next.
It's funny, and I don't mean this to be sexist, folks, but we find that's pretty common through the whole issue of elder care and planning, that this usually falls on the daughter, this usually falls on the daughter-in-law. And look, guys, you got to wake up. This is something that we're very capable of as well. I know from 4 parents over 14 years from personal experience. So I'm trying to get the gentleman out there, the adult children guys to wake up and take this responsibility off your sister, off your wife, off maybe a sister-in-law. We're very capable as well. So when someone starts talking to you from an elder law perspective, what are some of the questions you're asking that family, that individual? What are you trying to find out?
Well, the first thing I try to find out is whether they have any existing documents in place. Are they married? Are they single? Going back to existing documents, do they have a power of attorney, a medical power of attorney? Who has the authority to make decisions for them? And then whether they have those documents or not, I want to find out if they are still competent. Are they still legally able to make decisions? Because that affects kind of how our planning goes, if we're stuck with the existing documents or if we have to go get additional authority, maybe through a court or something like that. The other thing we talk about is what the assets are, what their income is, what their what they own, because certain government benefits depends on how much income you have, what assets you have, whether you're married or single, how those assets are held. So basically, we really dig in and we have to know a whole lot about a person in a very short period of time.
So let's take that a little bit further. So you're meeting with, let's say, a wife and a husband. We'll call them Mary and Joe. And Joe is the one that's aging, that possibly isn't doing that well, and you're pretty concerned about. From a Medicaid perspective, when does that come into play? Is that based on these questions you're asking, the answers that are being provided? Can you kind of walk through with our audience this Medicaid process, how that begins, and the process you go through as an elder law attorney?
Absolutely. So, real quick for your listeners, Medicaid is a very large federal program, obviously, and there's many different parts. But what we're specifically talking about is Medicaid for seniors for nursing home care. And a lot of people think that it's just for poor people. And really and truly, it's how the middle class pays for care. And depending on kind of where we are in somebody's care journey, depends on how we're talking, how we're having that discussion. So, for example, if we have a husband and wife who are coming to see me, and as you said, we think the husband might have some issues, then we have to look at and see kind of what's our time frame here. Because Medicaid, if we do any pre-planning, we have to look at are they going to be able to make it through the next 5 years before they need care, or if they don't, what type of care are they going to need? Do they need assisted living or full-on nursing home care? Because Medicaid pays for full-on nursing, but it doesn't pay for assisted living or memory care. And so we just kind of have to look at all that if we're pre-planning. And for pre-planning, often what we'll do is special irrevocable trusts. That may not work in every state. It does here in Texas. Well, if we're talking crisis planning, meaning he's here in the conference room with me today, but maybe he's going into the nursing home tomorrow, then obviously we don't have 5 years to wait, and then we look at what do we need to do to recategorize assets from countable to non-countable, how we're going to get qualified to save as much money as we can in the shortest amount of time.
I mean, this obviously, folks, sounds like a process, and it sounds like something that you need an elder law attorney like Aaron to help walk you through to make sure that it's done appropriately. On the one thing you mentioned there, and I think my audience knows this, or maybe some new listeners as well. Medicaid, and you said this, does not pay at an assisted living. I mean, there's very few where that's going to work. It doesn't pay for a memory care community. We're talking about nursing care in a facility like a skilled nursing building where Medicaid can actually pay that expense. Now, one thing people sometimes get confused about, and I think you work in this area as well, stop me if you don't, and that's benefits from the VA. So is that normally something that an elder law attorney like you gets involved in, helping someone that's a veteran? And there may be some other qualifications that you understand too. Can a spouse, someone else potentially get those benefits? But can you kind of walk our audience through VA planning, getting the benefits, etc.?
Yeah, absolutely. So the VA does have a really great benefit for veterans, or if the veteran has passed away, their surviving spouse. It's mainly called aid and attendance. It's technically a non-compensation pension benefit. I'm not sure why they call it pension, because it's not like you don't have to retire from the
Right.
military to get this benefit. And non-compensation means you don't have to have been injured in the service. So there's two types of government benefits: compensation. Or, I'm sorry, VA benefits. Compensation, which means you were injured in the service, doesn't have to necessarily have been combat related, or non-compensation, and that's what we're talking about here, meaning you have a benefit that the government's giving you, and you don't have to have been injured in the service. So this is a really cool benefit, but because it helps pay for assisted living, it helps pay for at-home care, it helps pay for memory care. Now, technically, it could help pay for full-on nursing home, but the benefit isn't a huge amount. It would help offset some of that cost. More likely, if we're looking at a nursing home, then we're probably looking at full-on Medicaid.
Sure.
But it's a really great benefit for those other places of care. And the key is you have to have been active duty. The veteran has to have been active duties for at least 90 days. Now, one of those days have to have been during a term of war. And this is a term of war means what Congress has determined as the time period of the term of war. It doesn't necessarily mean if you open up a history book and say, oh, it started on this day and this day. They're different time frames. But
Sure.
if you're active duty for 90 days, one day during a time of war, then they'll look and see if you have a discharge that's other than dishonorable, and then they're going to look at your medical needs. And there's three different levels. One means is basic level. Base pension is what it's called. The next level is homebound, and the next level is that aid and attendance. And whichever level you fall into depends on how much money you can get from the government, and the highest being the aid and attendance. So the base level, I don't make up the rules, but it just basically the VA says if you're over 65, then we're going to deem you to be disabled, and that's it. That's all the requirement you have to have for that. Housebound, meaning you're stuck at home. You don't leave the house except maybe go to the doctor, maybe go to your attorney, maybe the grocery store, but you're basically stuck at home. And then aid and attendance means you rely on the aid and attendance for other people for your activities of daily living, which are basically feeding yourself, bathing yourself, clothing yourself, going to the bathroom by yourself, and moving around by yourself. So then they also have some income tests and some asset test requirements as well. But it's a really cool benefit. It's not a huge amount. I haven't looked at it in a while. I want to say if you're married, you can get up to $2,000. If you're single, it's less. If you are a widow, I think it's around $1,000, maybe a little higher, a little lower, which isn't as great. But it is a potential benefit that people are unaware of. Now, I used to be accredited with the VA to do that. A few years ago, they made it very, very hard for me to help our senior veterans. And so I no longer have the accreditation myself. Some elder law attorneys will have it, some of them won't. But it is a really cool benefit for veterans. I just warn people, there are a lot of people out there who take advantage of our veterans, unfortunately, and they'll sell things like annuities or do things that might work for the VA, but if they're not careful, it could cause a problem if they get sicker and need full-on nursing home and need the assistance with that. So it's really good to work with an elder law attorney because who understands both benefits, because you really want to have one eye down the road, like what happens if this goes south. So you don't want to take a position for the Medicaid planning that'll hurt you for nursing home Medicaid.
No, and I appreciate that. And again, folks, I always express this. Please this is great information that Aaron has given you guys today. Please share this with folks around you, friends, family, colleagues. It's fantastic information, and I'm sure when Aaron was doing more VA and he saw this, and I've seen it throughout the 20 years I've been doing this, I'll talk to veterans that don't even realize there are benefits for them at the VA. Have you
Yeah.
experienced that, Aaron?
Oh, absolutely, absolutely. And the other thing that I get is veterans who have had to deal with the VA system and going to the hospitals, and they just get so disgusted that they don't want to have anything else to do with the VA. And I completely understand that. The good news is you don't have to go to VA doctors for this benefit. Unfortunately, you do have to deal with the VA, and I tell people the VA has been is probably the largest bureaucracy that's ever been in existence, and it lives up to its name quite frequently.
Sure.
I remember I would be on the phone, and these were back channels that they've created for attorneys. I'd be on the phone just waiting on hold for 45 minutes, an hour, hour and a half, just waiting for someone so I can get a status update on some of these cases. Yeah, I could get up on my soapbox. I just wish we treated our senior veterans a whole lot better.
Wow. But again, folks, it's money.
Yeah.
And the numbers I use in a planned age, it's about $5,000 across the country on average just to get a room in an
Yeah.
assisted living. Then you add care on top of that. So if you're getting 1,000, you're getting 2,000, whatever it may be, it's going to help offset that cost. The same thing using $40 an hour average for care in the home. It's going to offset that cost. So
Yeah.
folks, if you're a veteran, if you know a veteran and they're getting close to this situation where they may need care, you really want to help them understand it could be a process. It may not be the most fun process to go through, as Aaron's talking about, but the VA does have benefits if they qualify.
Yep.
So flipping the coin a little bit, now let's talk about the other side, estate planning. So what in the blue heavens is an estate plan, Aaron?
Yeah. So estate plan, like I said earlier, it just answers the question of who gets your stuff after you pass away. It typically is going to be either based around a will or a trust. Some of it depends a little bit upon where you live. Some of it depends on what assets you have, and some of it depends on how easy you want to make life for your family after you pass away. I usually tell folks, I don't know. I was never in one of these, but you might remember the Yugos. I think they're in the 80s,
Yeah.
a vehicle, made out of Yugoslavia. And
Yep.
yeah, like I said, I've never been in one, but I got to imagine a car that was worth, I don't know what it was, maybe $5,000 or so, may not have had the smoothest of rides. Could be wrong. Maybe Yugos were the best had the best suspension in the world. But my guess is it probably
Never
didn't
was in one either. Go ahead.
Yeah. So you can go down the road in a Yugo, or you can go down the road in a Mercedes SUV.
Uh-huh.
The question is, how many bumps are you, or really your family, are going to feel along the way? They're both going to get you where you're going to go, but how many bumps are you going to feel along the way? And the trust is more like the Mercedes SUV. And what a trust is basically a legal agreement between three parties. You have the grantor. Some states you'll hear it called the settlor or the trust maker. You have the grantor, the person that creates the trust. They set up the rules of the trust. You have the trustee. That's the person that runs the trust. And you have the beneficiary. That's the person that the trust is created for. And for a revocable living trust, the person that makes that is all three of those people. They're the grantor, the trustee, and the beneficiary. When they pass away, they're still the grantor, but we'll have a successor trustee step forward and manage the assets, and we'll have new beneficiaries. And the cool thing about trust is we can build all kinds of different things. If we have a kid maybe who's not so good with money, or maybe we're not super enthralled with our son-in-law, we can set things up so that the money stays in the bloodline. Or if we're concerned about our kids being able to manage the money, somebody else can manage it for them and make sure they get an appropriate amount every year. So there's lots of cool things. Now, a will, a lot of people think if you have a will, then that's it. You don't need to go through the probate process. And unfortunately, that's not the case. A will is a piece of paper that says who gets your stuff after you pass away, but to be effective, it has to go through the probate process. Basically, a judge has to say, yes, they've passed away, And yes, this is a valid will. And yes, this person is, in Texas, we call them executors. Other places call them personal representatives. This person is the one that's been appointed in the will, and they're not disqualified to serve as the executor. In other words, they're not well, in Texas, it used to be if you were a felon, it was completely off the table. You could no longer serve, you couldn't serve as executor. They've changed that rule just a little bit. You're a natural person. You live in the state, or if you don't, then you'll appoint an agent to receive service. So if your estate got sued, a lot of people think, again, if you have a will, you don't have to probate, and unfortunately, every state has a different period of time that you have to file for probate, and in Texas, it's 4 years from from the date the person passes. And if you don't, some gnarly consequences could happen, and I've seen it.
No, and that again, folks, this is fantastic information. I'm going to generalize, and Aaron kind of said it. Most people, when they think of this thing called an estate plan, they think of this four-letter word called will. And that's what most of us got taught when we were younger. But then as you learn, maybe you're an attorney, maybe you go to law school, maybe you live with an attorney, maybe you see something on TV, but there's actually this other word called trust. And what Aaron was just talking about. So what does it mean to die intestate, Aaron?
Yeah, to die intestate means to pass away without any sort of estate plan. So without a will, without a trust. Each state has their own plan for how assets are divvied up. And for example, in Texas, if we have a person that passes away intestate, again, without a estate plan, and they're married, it doesn't necessarily mean your spouse gets everything. It could, but it also could mean somebody else. Like, for example, I'll never forget this. I had a client called me up one day, and her mom was about to sell their house. And it was a Wednesday afternoon, about 4:30, and I got this call. Signing was on Friday. And the title company had discovered that the stepdad, my client's stepdad, had passed away, and had passed away about 10 years, 8 to 10 years earlier. But there was a will, and the will had everything going to my client's mother, who was trying to sell the house. But she never probated the will, and that's a problem because the gentleman who passed away had a child, and the child was an adult, but many years earlier he had sued his father and his stepmom because he thought that he should get paid for college, and that they should have paid for his college, and they didn't. Well, he created the fellow who passed created a will, had everything go to his wife. Great. But because they didn't probate, he treated as if he had passed intestate. He treated as if he'd passed without a will, which meant his half of the assets went to his son.
Wow.
And so when they sold the property, or they were supposed to sell the property, then half of the revenue that my client's mother was counting on was going to go to this other guy, the guy that they intentionally tried to cut out. And it's sad because, she thought she did all the right things. And just nobody tells people that, no, that's part one, but part two is you got to probate that will. And it just really depends. If there's no assets, then there may not be a reason to probate. Some attorneys would still do it, but it's the laws are different. The laws of intestate, what I find is people always assume they are however they want things to happen because that makes sense to them, which I get, yeah. But it can go completely different than what you expected. And so just get educated about it, and get an estate plan. That's the bottom line. That way there's no question.
I mean, what you just said, and folks, if you take anything away from this, and there's so much information here, get and estate plan.
Yeah.
And Aaron can correct me if I'm wrong. I mean, you don't want to go through probate. It's costly. It's public. It takes time. You don't want to go through that process. You'd much rather be driving that nice Mercedes he was talking about than a Yugo from 30, 40 years ago. You'd much rather be in control. Most people want their assets going to charities, certain individuals, wherever it may go, and we want that little C word called control. So
Hmm.
if you take anything from this episode today, get an estate plan, do a trust, make sure you're sitting in that. Maybe you can't afford it, but you're sitting in that Mercedes going down the street that's riding very smoothly. When do you encourage people to come to you? What type of age to start an estate plan?
Boy, when my kids turned 18, I got them powers of attorney, medical power of attorney, declaration of guardian, because they didn't have a lot of stuff that would need to be probated. We could beneficiary designate their bank accounts, which I don't always recommend, but in their case, it wasn't a lot. So right at the gate, if you've got somebody a loved one who just turns 18, at least the bare minimum. Power of attorney, medical power of attorney. We also do a HIPAA release. My theory is I don't want somebody who's in charge of making medical decisions without the ability to get the information they need to make those decisions. So we do that as well.
Sure.
And then declaration of guardian, and that's a document that says, listen, if I am unable to manage my own affairs, then this is the person I want to take care of either me or my stuff. But yeah, so that's the first level. Definitely, if a couple has kids, it's important to name guardians for the children. So what happens if you don't make it home that night? Let's say you're out, you got a raise at work, and you want to celebrate, and you take your wife out to dinner, a nice steak dinner, and somebody on the way home takes a turn too wide, and you don't make it. So who's going to take care of those children?
Sure.
Which is huge. Really any time after that. If you don't, I don't know who said it first, but what's the saying? The best time to plant an oak tree is 20 years ago. The next best time is today. There is a too late, and that's if you're no longer able to make decisions, then that's
sure.
tough. If I've done many estate plans on a hospital bedside, and I know that they would rather spend time with their loved ones than with an attorney hovering over them, making sure they sign correctly. But yeah, any time after you turn 18 is a good time to start planning. But definitely when you have kids, definitely if you get older, then you might switch to an elder law attorney, thinking about how to protect your assets and pre-plan and things like that. And that's any time that's 5 years before you get sick. So 60, 55, 60, some 65, that's always a good time to start looking at that.
Now, again, folks, that is fantastic advice. When do you recommend that people update the estate plan? Every 2 years, 3 years, 5 years? What's your recommendation, Aaron?
So for intervals, I recommend, at least for us, what we do is we reach out every 3 years because I tell folks, listen, if the law changes, if your health changes, if your stuff changes, if your family changes, any of that, a plan that we've done for you 3 years ago may not work for you because, it's different now. It could be 100% perfect at the time, but things change. The other thing is, if you've got a loved one that's passed away, or maybe a new one born, or maybe you were real good friends with the people that you picked out as guardians of your kids 5 years ago, but now maybe not so much because you moved away or they moved away. You moved to a new state. That's always important. Estate plans are, if they're effective when the state they were in, they'll be effective now, but they may not be as smooth to deal with. So, for example, I get a lot of folks that come in from California. They have trust, which is great. But in Texas, there's a paragraph that we put into their trust to ensure that the trust is a tax qualifying trust under the Texas tax code. And what that means is they can get their homestead exemptions, which is allows you to pay lower property taxes. And if you don't have that paragraph, then the counties often will try to charge you extra property tax. So things like that. So if you move from another state, if your family's changed, if your assets have changed significantly, it's always a good time to call and update.
Again, folks, fantastic advice. As we get ready to wrap up, I do have one last question. So you're working with a couple, they do have assets, they've put an estate plan together. One of them, again, we'll call them Joe and Mary, needs care. They move off to an assisted living. Maybe they're getting care in the home and they're not really communicating with you. And my question is, should they? Because they start selling assets that they have to be able to pay for care, and should they be getting appropriate advice, especially from any tax consequences before they start selling certain assets? Maybe the number of hours at home has increased and they need more money on a monthly basis.
Yeah, it's tough. Yes, absolutely. They should call an elder law attorney. One of the things I see a lot is mom and dad will give the kids their house. And that's great in that it does avoid probate. But the problem is, number one, the kids will lose a homestead exemption, so they'll have to pay a higher property tax. Number two, if the house is appreciated significantly, then what they would do is they would have to pay tax on the difference in what their parents paid versus and what they sold the house for if they sell it down the road. Whereas if they get the house through an inheritance, they would only have to pay tax on the difference between what the value of the house was worth at the time of death and what they sold it for, which is going to be a smaller number. And so we call that a step up in basis in tax terms. And so people just people just don't know what they don't know.
Sure.
And that's happened with my family. Again, you mentioned earlier, that's why I got into elder law, or one of the reasons is, when my grandmother went to a nursing home, my grandfather reached out to his pocket for 10 years and paid for her care.
Wow.
And when she passed, it was like 3 to 5 years afterwards. And then he needed care. And then there was no money left because he'd spent it all.
Yeah.
And that fell to my aunt, my uncle, and my dad, his kids, to dip into their savings, to dip into their retirement. I mean, he passed, I don't remember, I want to say 20, 25 years ago. And we're still feeling it because my dad is 76 years old and he's driving a truck right now. Part of it's because he wants to, but part of it because he needs the income. Yeah. And it's but nobody has told them about the different types of benefits. They had the opportunity twice. Like when my grandmother was in, somebody could talk to him. When my grandfather was in a nursing home, somebody could have talked to him, and they just didn't know to ask. So that's one of the reasons why I do what I do and why I'm on programs like this is I really want people to understand that there are options out there. Get educated, learn what's available, what you need to do. So you don't just make an unforced error, to use a sports term, right? You don't make a mistake that's going to cost you.
Now, this is, folks, as we do get ready to wrap up, this is fantastic information throughout the episode today, what Aaron just talked about and the story that he related and just that lack of understanding. You don't want to be in that position. If you do have questions, if you don't have an estate plan, reach out to someone like Aaron. As someone is aging, reach out to someone like Aaron. Might they qualify for Medicaid? Might they qualify for VA benefits? There's a lot going on, and I know we all have so much going on in our life, but the story that Aaron's relatives learned from, the story that my family learned from the hard way with taking care of 4 parents over 14 years. Learn, get educated. It's really going to help you and help your family. So, Aaron, is there contact information you'd like to give out? An email, a phone number, a website?
Yeah, absolutely. They can reach us at aaronmillerlaw.com, AARONMILLERLAW.com. On the internet, they could shoot us an email at info@aaronmillerlaw.com, info, or give us a call, 214-292-4225, 214-292-4225. We can help with Texas-based cases if you are in another state. We have a lot of contacts in other states as well. So, yeah, we could definitely help.
Thank you, Aaron. This has been fantastic. Share all this information, folks. This has been 35 minutes of great information that Aaron has provided for you. So as I say, as we end every episode, till we talk again, have yourself an awesome day.